Now, mediation is a really good process and it's quite high success rate in settling matters without proceeding to court. My advice usually would be to see a lawyer before mediation, so you know your options, you know what you can achieve in your matter, and parties can absolutely approach a mediator directly without being legally represented. It works, it happens a lot in parenting matters. However, in more complex matters, from my experience, mediation would work if it's usually full day. Half day is quite short time to discuss everything, and when it's legally supported. Now, it would require lawyers and parties to do some preparation work before they attend the mediation, but people are committed, and when both parties are committed to resolution, mediation could be successful. So, number one, see lawyer first, get advice about your options for parenting or property matters, and you can attend mediation without lawyers or with lawyers. Again, in complex matters, legally supported mediations work better. It's a very good question. So there is a section of the Family Law Act, section 63C, which tells us what parents can include in a parenting plan. But I would say there are three main blocks when you discuss arrangements about your children and you want to include them in a parenting plan. The first big block is how you exercise your parental responsibilities, so how parents make long-term decisions about the children. Some decisions like school education, religion, health. You can put a mechanism how you make those decisions, or if you made a particular decision or you reach an agreement about, for example, attending the child attending specific school, you can straight away put it in a parenting plan as agreed item. Now, the next big block is live with and spend time. So how children or child lives with both parents and how they spend time with both parents. It could be live with one parent and spend time with other parent. It could be some shared care. Now, and the third big block, it's kind of residue of other things, such as travel, passports, communication, how you can put some restraints in the parenting plan. You might just say parents are restrained from consuming alcohol when children in their care. Parenting plan is not legally binding, but for purposes of sticking with the agreement, sometimes parents put some restraints. It's often we see non-denigration clause where parents are restrained from denigrating each other in front of the children. You can also put provisions how you change the parenting plan. So sometimes we see parents would attend another mediation in 12 months or other mechanisms, how they appoint a mediator if they unable to reach the agreement about the particular point. But parenting plan is a really good document. Again, it's not legally binding. It's good for situations where parents just separated and they want to test something for, let's say, 3-6 months, how the arrangement would work. Parenting plan could be later transitioned to consent orders. This is where you see a lawyer and lawyers will help with this. But these are the things we usually see parents include in parenting plan. Okay, the first important thing to remember is mediation is confidential, and what happened during the mediation discussions, offers, they are privileged, they cannot be disclosed to court or third parties. There are some exemptions, but generally speaking, what you agreed during the mediation, if you haven't signed any document, either party can change their mind. And what we see happening, if parties reach an agreement and they're confident that they're okay with this, we sign heads of agreement, and we sometimes place cover sheet saying this is not a legally privileged document. You need to seek legal advice before doing that, but that's kind of what lawyers do to prevent the hardly reached agreement, which parties would spend a full day sometimes negotiating, not to fall apart because someone changed their mind next day. But to answer the question, if the other party is not longer agreeable of what they've discussed during the mediation process, there is no agreement. You might just negotiate it further, you might just book another mediation to discuss those specific things, but if there is no agreement, there is no consent.